Welcome back. We're going to talk a little bit about the foundations of law, where law comes from, how things become a law, particularly statutory and regulatory law. We're going to start at the beginning. We're going to go way, way back. So, the legal system that we have today is evolved from the English common law system, which dates back 1,000 years or more. And it's essentially designed around the concept of precedent, which means essentially that the stories that are told in court are documented, what the decisions were and why, and those are called opinions. And those opinions are then referred to by other judges over time in order to be able to help decide new cases. And so a lot of the law that we have has been built over 1,000 years of case law and precedent. And what governs case law and precedent is the United States Constitution. So the United States Constitution was drafted in 1787 and ratified in 1789. So it is over 200 years old. And it comprises multiple parts. The parts that are probably most relevant to the discussion here are Articles 1, 2, and 3. So Article 1 is the Congress, Article 2 is the presidency, and Article 3 is the court system. And each of those articles separates the powers out for the president, the Congress, and the courts, and lets everybody know what their job is and how a bill becomes a law and what the process is to establish statutory authority. There's a number of components in the Constitution, and the one that is probably most famous is the Bill of Rights, which came in 1791, so several years after the Constitution was written. And that's, your First Amendment, freedom of speech, freedom of religion, freedom of the press, all the way through the 10th Amendment, which essentially says if something isn't stated in the Constitution, those powers are reserved to the states or to the people, which becomes a pretty important piece when we talk about where the law is enforced and how to access the court system. Because Article 3, which is where the Supreme Court is authorized, spells out what the jurisdiction of the Supreme Court and federal courts are. If it's not in federal jurisdiction, then it falls to the state courts. And so you can only get access to the federal courts under certain circumstances. And we'll talk about those circumstances in the next lecture. But it's just important to remember that there's the base Constitution, and then there's the Bill of Rights, which were ratified in 1791, and that's the first 10 amendments. And the 10th Amendment reserves anything that's not in the Constitution, not specified in the Constitution, is reserved to the people or to the states. There's now 27 amendments to the Constitution, the last one being ratified in 1992, and a little bit of a history on that one. It actually was proposed way back in 1789, 1790, and it wouldn't allow Congress to vote itself a pay raise. And so Congress could vote a pay raise, but it could only take effect for the next Congress. So 2 years, up to 2 years later. And so interestingly, in 1992, a student had been doing some research on constitutional history, identified some of these amendments that were sitting out there unratified, where were missing a few states, and he rallied around the United States and got a number of other states to ratify it, so that this amendment, the 27th Amendment, ratified in 1992, the first votes for ratification were back in 1790. And so some amendments, like the Equal Rights Amendment, for instance, had a time limit. So they said if it's not ratified by a certain date, by all the states that require ratification, 3/4 of the states, then it went away. But the 27th Amendment did not have that language in it. And so as a result, it was ratified almost 200 years after it was originally proposed. There's 27 amendments, And they range anything from whether you can sue the government or not, 11th Amendment or 12th Amendment, all the way through to whether Congress can vote itself a pay raise, changes to the Electoral College, changes to making alcohol legal, illegal, giving the vote to 18-year-olds. Pretty much everything is in there that you can imagine, with the piece that, if you think back to around 1920, 1922, the federal government felt like, or society, again, going to the lecture where the law tends to lag society. Society wanted to abolish liquor. And so the society at the time felt like this was such a big deal that it required a constitutional amendment to essentially make liquor illegal. And then there was a subsequent amendment, the 21st. So the 18th Amendment made alcohol illegal. 21st Amendment made it legal again. And so interestingly, there's, now we have laws which make narcotics illegal. If this was back in the late 19th century, early 20th century, I bet you there would have been a thought that the only way the government could do that was through constitutional amendment. Now it's done by law. So again, the Constitution has changed a lot, and the 27 amendments has changed a fair bit over the last 200 plus years. And the changes that have occurred have largely been a response to societal changes. So originally the Senate was appointed by state legislators. It is now elected directly by the people. Women didn't originally have the right to vote. Now they do. So those are all components that have changed. So there's been 27 amendments. Now I'll give an example, and as we go through the course, most of the examples I'm going to give are going to be from the state of Washington. It's the state in which I'm admitted, and it's the one with which I'm most familiar. And again, as we talked about just a few minutes ago, the Constitution reserves a lot of rights and powers to the states. So each state also has a constitution. And the state constitution is something, depending on what state you live in, you may want to just, Google it, take a look at that state constitution, because it's going to have different powers and requirements for the state than the federal constitution does. If there's a conflict between federal and state constitution, the federal constitution has supreme power. And there's a supremacy clause in the United States Constitution which says that. However, if the U.S. Constitution is silent and the 10th Amendment says that all powers not specifically enumerated in the U.S. Constitution are reserved to the states, then the state can provide for a different level of either freedom or restriction if it's not part of the enumerated powers in the federal Constitution. And so the Washington Constitution has over 104 amendments as of 2010, which was the last amendment to the Washington Constitution. So if you think 27 amendments over the last 200 some years is a lot, the state, Washington State, in my case, has over 104 amendments. And it is amended routinely for things like adding appeals courts, adding the ability to have vote by mail. And so a lot of the constitutions of the states have been changed and amended far more frequently than the federal Constitution. And if you're going to really be a student of the law, it's important for you to not only analyze the federal Constitution, and you'll see that, that's what lights up, Facebook and the Twitterverse. But the state constitutions are probably far more critical to how you live your life, because that impacts how your state government works, how your county government works, how your local governments work. That's all going to be contained in the state constitution. And a lot of us don't even know that the state has a constitution. So that's just something to keep in mind as you begin to learn the law. Laws are developed through two components. And again, this is something that, until I started studying the law, I was really blindly oblivious to. So the first thing is you have what you think about as the creation of a law, and I've linked the Schoolhouse Rock video to give you a little bit of flavor to how a bill becomes a law. But essentially, what happens is a bill is proposed, it goes into committee, it's in either the House or the Senate, and it'll come out of committee after negotiation is voted on the floor. Then, if it's passed, it goes over to the other house. So either the House or Senate, whichever one it didn't originate in. They may pass it, or they may pass a similar one. Then, if there are differences between the House version and the Senate version, they get together and essentially have a conference where they negotiate between each other to deconflict the bills, and then they go back and vote them again. And once they're deconflicted and they vote yes, they move forward to the president or to the governor for signature. On the United States, on the federal side, the president can either veto, so say yes, or can either sign the bill and say yes, it's good to go, in which case it becomes a law, or the president can veto the bill and basically say I'm not going to sign off on this bill, and it goes back to Congress, and Congress then has to pass it by 2/3 in order to override what they call override the veto and make it into law beyond what the president, if the president said no and they override the veto, it becomes a law anyway. At the state level, most states, the governors have what's called a line item veto. So with federal, the president has to either accept or reject the bill in its entirety. So it's either the whole thing becomes a law or none of it becomes a law. At the state level, most governors have the ability to line item veto. So they can go, I want these sections to become law. I want to veto these couple sections. I want to allow this to occur and not allow those things to occur. And they scratch off the line. And then that's the line item veto. And then, again, the state legislatures can go back and decide whether to override that veto or not. So the federal and state have generally different, the executive has a different veto power. In both cases, and this goes back to an old Supreme Court case called Marbury versus Madison, and I won't give a bunch of the case history, but you can go look it up. It's a really famous case. Essentially, the Chief Justice of the Supreme Court at the time, who was probably the most famous Chief Justice that we've ever had, a gentleman by the name of John Marshall, wrote an opinion that said, because we're in the English common law structure, and the courts need to understand what the law is, the courts determine what the law is based upon what's been written and what precedent is, that the court has the final say in whether something is permissible under the Constitution or not permissible under the Constitution. And so Marbury versus Madison essentially set the record and set the precedent that the U.S. Supreme Court can review a law if there's a case or controversy, so if there's a dispute about the application of a law or the constitutionality of a law. The U.S. Supreme Court could review that law and then determine if it was constitutional or not constitutional. If it's not constitutional, the law gets thrown out just like a veto, and the only way to go around that is to either pass a constitutional amendment or modify the law to address the unconstitutional component. Each state, and again, we'll talk about this in a moment, but each state also has a Supreme Court which generally follows the exact same set of precedents. So if it's a state law, it goes up through the state court system to the state Supreme Court. And so that's the legislative process. Congress passes a law, the executive signs or vetoes, the legislative branch can override that veto, and then the courts will determine whether the law is constitutional or unconstitutional based upon a case or controversy or a dispute. The regulatory process is a little bit different, and it's one that is going to be very critical for you to understand as a business person. Generally, when these laws are passed, they provide direction to the executive branch that says, and I'll use an example. In the 1970s, the Environmental Protection Act was passed, and it directed the executive branch to establish the Environmental Protection Agency and to develop regulations to provide for clean air and clean water. And so what ended up happening was Congress delegated to an executive branch department the ability to set the regulations. So how much sulfur could be emitted, or how much acid could be emitted, or what types of solids or what types of liquids could be discharged into sewer systems, for instance. And these regulatory agencies set the regulations, and then they have a law that oversees how those regulations are developed, called the Administrative Procedures Act. And each one of these federal regulatory agencies has a whole set of regulations which have the force of law, because the law said, Environmental Protection Agency, you shall develop regulations that tell people what they can discharge into a stream, for instance. However, Congress didn't vote on what those regulations were. They just said you need to have regulations that provide a certain outcome. And so as a result, you've got a regulatory process which is outside that legislative process. So there is no veto power. There is no line item veto. Congress or the state legislature doesn't vote on the regulations generally. They just go through an administrative procedure process where regulations are drafted, they're published, there's hearings where the public has an opportunity to weigh in, and then they're either adopted or shelved. If they're adopted and people violate the regulations, it has the same effect of violating the law. However, then you would follow the same process where you would appeal it into the courts, and the courts will run through their normal approach where you can appeal it up to the Supreme Court, whether it's state or federal. There is, however, a precedent, and it's called Chevron, the precedent is called Chevron deference. And essentially what happened in Chevron deference is the U.S. Supreme Court said, if there's a dispute about what the regulation really means, we're going to defer to the administrative agency, who's got the experts in whatever that regulation is. And so essentially what you've got now is a legislative process which develops laws which are somewhat general in nature, and they go through the I'm just a bill, and goes through the voting process and a committee process, and then goes up to the president and it's signed or vetoed, etc. If that law passes, and say it's something like the Environmental Protection Act, it then moves over to a federal regulatory agency for the regulations, the enacting regulations, to actually be put into play. And so for most of us who are in the business world, we run into regulations all the time. Your unemployment regulations, you've got regulations around workplace safety, you've got regulations around insurance, you've got regulations, all those regulations on how you register your car or your business vehicles, regulations on things like zoning regulations for use of your property. Those are all regulations, and those regulations, that process of the legislative passes, the executive approves, and an administrative agency actually develops the regulations, occurs at the local, county, state, and federal level. So it's important that you understand that you might see a law passed. That law is going to have regulations attached to it, most likely, and those regulations, the development of that regulation is going to occur outside of the normal law process, and it still carries the weight of law, and you've got to understand how to kind of interact with both pieces. One of the most important things you could do as a business person is to stay plugged into the administrative agencies which impact your business, whether that's workers' compensation, whether that's business licensing, whether that's planning and development or zoning, and make sure you understand what regulations are coming and what regulations change, because those regulations they'll put up a change to regulations, and each president, for instance, can change regulations, because it's the executive agency that does it, even if the law doesn't change. So regulations change much faster, much easier than the law does. So that's the foundations of U.S. law. Next, we'll dive into the court system. We've touched on it here already. We'll dive into the court system and talk about how these laws are then enforced.